This is the 13th video in this series. It's a continuation of the custodian-dependent relationship. I consider it the most fascinating application of inalienable rights. But if you're not thoroughly familiar with the preceding videos, I don't recommend this one. Okay, mind wide open? Here we go. A dependent's rights are violated in the same way as anyone else's, by the initiation of physical force. Probably the most notorious examples of violation by a custodian are the cases of abuse, molestation, and endangerment. More on those later on. One is, of course, always within one's rights to provide care to another, provided there is no legitimate objection from the recipient. As an example, suppose you offered a friend a ride in your car and he accepted. You would then be extending a form of care, since while on the road his health and well-being would be affected by the manner in which you drove the car. If you jerked the controls violently so that he was thrown about, you would be providing care to him in such a manner as to cause harm. You would be guilty of violating his rights, unless, of course, he had agreed to such treatment. Under normal circumstances, his acceptance of the ride would be with the unspoken agreement that he be let off unharmed afterwards. If, whilst moving at high speed, you were to tell your friend that he was no longer welcome in your car and to get out, you would be withdrawing your care in a manner that caused harm, since compliance would result in certain injury. Likewise, if you left him stranded in the middle of a desert, hundreds of miles from civilization, you would be the cause of his suffering and eventual death from dehydration. Thus, in order to provide him with a ride in your car without violating his rights, you would be obligated to give him a tolerable ride and a safe arrival at the agreed-upon destination within a reasonable time, and so forth. He would be entitled to this much. I use the term entitled to rather than a right to, because in such a situation he has no right to a safe and timely arrival at his destination. You are giving it voluntarily, but in a practical sense he is entitled to it, or some equivalent, because without it he would be harmed. There are many reasonable and peaceful alternatives. For example, your plans may change abruptly and you have to leave him at a bus stop or train station. Or you might get out at your own destination and let him borrow the car for the rest of the day. The essential point is this, and I find this absolutely fascinating. While it is true that you cannot violate a person's rights by not providing support to them at all, you can violate their rights by providing support or withdrawing it in a manner that results in harm. In cases where the dependent is unable to recognize when his life is in danger, such as small children, numerous controversial issues arise, as we shall see later. For now, it is reasonable to say that one cannot assume that the dependent has consented to be harmed in any way. To play it safe, any care provided ought not to go beyond the basic necessities of food, protection, and perhaps some simple entertainment. One cannot assume that a dependent child has consented to any unnecessary risk, such as being taken for a wild ride on the back of a motorcycle. Let us briefly consider the possibility of the dependent objecting to simple life-supporting care. I think it is reasonable to assume that, in the usual case, an infant, assuming he were able to voice his wishes, would prefer to live and would not object to the care his custodian provides. Thus it is reasonable to provide care to a young child even though he cries, throws tantrums, and so on. In a future video I'll examine extreme cases such as that of a dependent who is seriously ill, cannot be saved, and who may prefer to be left to die. Obviously there is no contract between a custodian and his dependent, nor is there any such thing as an inalienable right to be cared for. So it is not proper to say that the dependent has a right to any form of support or protection. However, because the parent is in the process of providing support, the child does have some claim upon him. The unspoken claim a child has on his parents is this: if you, the parent, are going to take care of me, the child, which you have every right to do, then you must do it in a way that causes me no harm, that does not violate my rights. So in practical terms, you must supply me with the basic necessities of life and well-being. And if you, the parent, wish to withdraw your support from me, the child, which you have every right to do, you must likewise do it in a way that causes me no harm. So in practical terms, you must care for me until you can find someone else to take over the job, or I grow up and move out. Now we must consider childbirth. A newborn baby is completely helpless. Without the assistance of a custodian, he will die of exposure or starvation within a few days. During pregnancy, the mother has been providing care to her unborn child. Following birth, the infant requires the care of an adult or he will soon die. At the moment of birth, we generally recognize that simply by being in the presence of her newborn child, the infant is in his mother's care. When she first picks up the infant and holds him in her arms, it becomes impossible to deny that she is providing care. Thus, if she withdraws her care from the newborn infant, she will be taking an action that results in harm to another person. From the moment of birth, the new mother must continue providing care to her infant unless she can find someone else to take over, such as give the child up for adoption. Parents usually recognize the helplessness of their children and feel very protective of them. I know I certainly did. We were willing to expend enormous effort and great sums of money to ensure that our children received the finest care available. There is still one more case that must be examined. It is entirely possible for a woman to become pregnant as a result of being raped. Assuming she is unable to safely abort her fetus and instead gives birth, she may then find herself in the unfortunate position of being the custodian of an unwanted child. I think it could be argued that not only were her rights violated when she was impregnated against her will, but that an additional violation occurred when she was forced into the position of an unwilling custodian. If she abandons the child and it is harmed or dies, I think it could be argued that the violation to the child is primarily the fault of the rapist. Along these lines, we must also consider the case of a parent who can no longer care for his child and no assistance can be found. For example, a father takes his young son for a walk in the mountains. The father falls off a cliff and dies. His son wanders alone for a few days before starving to death. Did the father violate the rights of his child by withdrawing care in a manner that resulted in harm? To the extent that it was carelessness on the part of the father, then yes, but I think the tragedy of the accident overshadows it. All of us, I'm sure, have wondered whether, after growing up and moving away from home, we owe our parents anything. We can see that a child ought to be grateful for the effort his parents provided. I certainly was, but it is not necessary to repay it. The support was freely given. His parents raised him because they wanted to, not because they were fulfilling the terms of any contractual agreement. As every action that results in a violation of rights calls for a law to forbid it and a prescription to remedy it, let us establish a fundamental view. The law should say, if you provide support to someone in a manner that results in harm, you will be violating his rights. You must stop doing this, or an agent of the law will intervene and rescue the victim. So, with such a law in place, what the custodian must do is find a way to provide support that does not result in harm, or transfer custody to another. The law should respect his right to select any peaceful method. Let us consider an extreme example. You live in a grass shack and can only afford to eat canned beans, while your neighbor lives in a mansion with servants to satisfy his every whim. You cannot afford professional medical and dental treatment and a college education for your child, while the children next door have the best of everything. Can you be blamed for your child growing up in relative poverty? Is it reasonable for anyone to impose minimum standards on you and to take your children away if you cannot afford to meet those standards? I will argue that the establishment and enforcement of these kinds of standards should only be done by agreement, which means, as I described in video number 11, the CC&Rs, which means that the law should only be used to settle disputes concerning agreements among neighbors. Anyone who finds himself living in a neighborhood with CC&Rs not to his liking is always free to convince his neighbors to change the CC&Rs, or, failing that, move away. I've observed both in my neighborhood. Thus, I think we would find that over time, people who prefer to raise their children barefoot in a grass shack would leave Beverly Hills and move to a South Pacific island. It should be clear by now that government funding of education is improper. So what alternative is there? Does it mean that everyone seeking an education would have to purchase it at the time of use? This idea is at odds with the traditional community school for children. Let us consider the issue further. When one lives in a residential neighborhood, one finds oneself surrounded with neighborhood children. Your own children bring friends over to play, and even when they grow up and move out, they have children and bring them over to visit, and the cycle starts again. Even if you have no descendants of your own, you get to know your neighbours' children and perhaps entertain them at your home, play football with them in the front yards and local parks. You occasionally find yourself acting as a substitute parent. So the point is that while you are a member of a community, it is usually in your interest to provide a little care to all the children who live nearby. So what happens when the parents are away at work? No one wants the neighborhood children running wild and getting into trouble. Thus it is in everyone's interest to have a place for them to spend their days, play with their friends, be protected, cared for, and learn as much as possible in preparation for the day when they will want to have careers of their own. Neighborhood recreation centers with co-located schools would seem to be the ideal solution. I think it is reasonably likely that we would see homeowners associations funding the basic daycare and teen center facilities and supervision, paid for, of course, by the members' dues, and classes for children of all ages would be provided by private schools that would charge for each class attended. As mentioned previously, these schools would most likely be adjacent to or co-located with the neighborhood-funded centers, so that children could play, socialize, and nap between classes, all on the same grounds. This would then provide the same services as the current government-funded public school, but with the advantage of allowing subjects of a far more controversial nature to be offered. Funding for the basic courses popular with all students, such as physical education with their associated playing fields and specialized equipment, could of course be provided by the neighborhood if it was economically advantageous and approved by all property owners. It is even possible that homeowners would be willing to fund the centers to the extent that they could remain open and manned at all times, thus providing a reliable, convenient, and safe haven for children in the event of an emergency. Let us now consider the question of a merchant being an accessory to a trespass. If a parent forbids his child to take some action, such as purchase candy from the local grocery store, and the child does it anyway, we would not blame the grocer for his ignorance of the parent's policy. It would be absurd to suppose that we could hold the grocer responsible for the child's act of trespass against the parent without the grocer knowing of it. If a parent prefers that his child not purchase certain items, then the burden is upon him to restrict the child's ability to do it. Offering goods and services for sale, buying and selling, does not involve the initiation of force unless the seller deliberately misrepresents himself or his product. This is called fraud. A peaceful trade is an action that necessitates the consent of all parties. It doesn't matter who buys or who sells, and it doesn't matter what commodity is traded. There is no violation of rights. Such transactions are perfectly proper. A proper government would not outlaw any commodity. It would only outlaw forceful and fraudulent actions. What the parents need to do is persuade their neighbors, including the local merchants, to tighten up the CC&Rs such that everyone agrees not to sell certain items to children without the parents' permission. Merchants who break their agreement would then be prosecuted, put out of business, or evicted. With all property privately owned, visitors who offered undesirable goods and services for sale on street corners, alcohol, tobacco, firearms, explosives, drugs, and so on, would be treated as trespassers and likewise evicted. Eventually, with HOAs following each other's lead, it is likely that the same list of goods and services would be forbidden in all residential areas popular for families. Their use would be limited to business districts that perform forensic tests, chemistry experiments, and perhaps some remote adult-only communities. As I'm sure you can guess, this would constitute the privatization of that enormous list of controlled substances. But back to children and other dependents. Drinking and driving are fairly straightforward. The custodian, in order to provide care without causing harm, must allow access to the alcohol and motor vehicles he owns only to the extent that the dependent can handle them without becoming a danger to himself and to others. Signing contracts is not so obvious, but still the same principle applies. I think we can argue that a custodian must forbid his incompetent dependent to sign his life away. He can do that later, when he is taking care of himself. Voting is more obscure still. If we were to prevent the incompetent from voting because we fear he might cast his ballot for a candidate or issue of which we disapprove, that would make a mockery of the entire concept of voting. I'll continue in video number 14.